Good morning, Mr. Adams.
Good morning. May I proceed, Your Honor?
Yes, you may, certainly.
Chief Justice Marshall, Justices, may it please the Court, Samuel Adams on behalf of the guardian appellant and petitioner below. The main issue raised by this appeal is whether or not the best interests of a child, a minor child, weigh in on all questions of visitation and custody, at least between a biological parent and a de facto parent. The court below found that the petitioner was a de facto mother, that the child's best interest to give her visitation, but she could not award custody unless the mother proved the father was unfit. The mother was the child's only primary caregiver from the time the child was 14 months until the child reached 8, when our second motion to stay pending appeal was denied by the trial court.
May I?
Go ahead.
Just on those facts, you say the mother was the primary caretaker.
Yes,
but
yes, Your Honor.
didn't the father have quite a bit of involvement in the child's
He
life?
had some involvement, yes.
Well, rather than some, didn't the judge find that the father was quite involved in the child's life?
Well, there were various findings, that some of which were inconsistent. I will get to those, Judge Ireland. But yes, he was involved. The period of 6 or 7 years, he brought the child to the guardian. And then they lived together further periods of time, and then, he pulled out. But he was involved, but he was never a primary caregiver.
Mr. Adams, have we ever held before that a de facto parent has rights superior to those of a biological parent?
You have in the...
Who is still fit?
Well, okay. Yes. In the Yeomans case, Yeomans versus Ramos, written by Chief Justice Marshall, you gave visitation to a de facto parent.
Right, but I'm asking if we've held that the de facto parent has rights superior to those of the biological parent.
No, not superior, equal. It should be on the best interest of the child test. Nothing superior. They should be treated equally. Yeah, that's the argument I'm making. They're both parents. And in the case, I think Justice Graney decided it Blixt, in which he referred to the fact that parent was defined as a mother or a father, but the mother or father was not defined as being a natural parent or a de facto parent. So there is should be no distinction.
So once there's a finding of de facto parent, these are, for all legal purposes, the two biological parents.
They're equivalent, yes.
Equivalent.
That equivalent, yes.
Do you think, I appreciate what you say, that you find some of the findings inconsistent, but do you think that, do you read into the decision of Judge Moriarty that were she not, in her view, constrained by the fact of biological parentage in the father, that she would have granted custody to Ms. Dawson?
I do. And some of the findings she made are just overwhelming. The secondary issue is actually whether or not the evidence is so strong as to decide that he is not fit. But that's a secondary issue.
Is the child now in Florida with the father?
He's with the father, but not in Florida.
New Hampshire.
New Hampshire.
That's because the judge refused to stay the decision, is that right?
The judge refused. 2 attempts was made by trial counsel, one motion to stay and one emergency motion to stay, in addition to a motion to alter or amend, the last of which was denied in November of 2006. And at that point, the order took over.
So the child's now been with the father for...
About 2.5 years.
You know, when you talk about this second point about whether the judge's findings, finding the father fit, should be overruled. I think that's what you're suggesting. That the trial judge found that the guardian was not believable in a number of different points, that she overstated the facts. And there are a number of times where the judge said, I find the guardian's testimony not credible.
And she found the same of the father, Your Honor. That is true. But the things that the guardian was not credible were, as I read the decision, was that she exaggerated the abuse. There's no question there was evidence of abuse by the father of the guardian and indirectly of the child. But she exaggerated that, was one thing she found fault with, and the other was that the guardian lied about her age. She made herself much younger.
The judge did more than that. The judge at one point said, I do not find she is credible and reliable witness, and find further that some of what she alleges did not happen. And another point, the judge says some of the guardian's allegations as to frequency and severity of incidents are much exaggerated. And then the judge says, I also find guardian has overstated in some instances what has happened, and that some of her more extreme accounts cannot be corroborated. Guardian's credibility is suspect. She has provided a false birth date, has used multiple Social Security numbers, has not been candid about her true relationship with child. She has collected her disability under a cloud of uncertainty. She did not disclose to her own landlord that father and child were living with her. She has been inconsistent, and goes on to say, I find guardian's testimony as to threats to child and striking of child not credible. So the judge did more than just say she exaggerated about her age.
Well, that's the way you can read it that way, Justice Ireland, but we also have the balancing, if you want to balance the credible about his lying to the court, about his not having a criminal record. I mean, if you want to balance out who's not telling the truth the most.
Isn't it ultimately up to the judge?
Well, it is ultimately.
She made credibility findings.
Yes, but she also made a finding that the child should not be punished by the fact that his father considers he's not been done justice, that the father considers himself a victim of the judicial system. Child should not be punished because, says the court, it is finding it's in the best interest of the child that he be with the father. She never made such a finding. She said the father is entitled to custody unless he is, by clear and convincing evidence, found to be unfit. She never found it was in the best interest of the child to be with the father. So it was a trump card. All of this recital about the mother, and I mean, you read that decision and see all the things she did. Yes, she fell down here and there, but he collapsed here and there. He was in contempt of court. He told, he had falsehoods represented to courts in Florida and Massachusetts. I mean, it's a terrible scene. But to say that he wasn't proved to be unfit, and I say it's a secondary issue, is stretching the imagination. This is a 13-day trial, so everything came out. Unfortunately, much of the evidence is reported by the trial judge and not without findings. But she did excuse herself by saying that she didn't make findings. She didn't make findings because she wasn't able to. If I may find that, I'm sorry. Such a long record. The guardian testified as to numerous occasions when the child was present. That's not what I'm looking for. The child was actually injured on one attack on the guardian, and when the evidence came in, That part? I'm sorry.
Well, she does make a lot of findings. I mean, you're
does
right. She
make a lot of
recites a
findings.
lot of the evidence, page and page and page, on and on. And doesn't classify them as findings. But in her discussion section, she certainly makes a lot of findings.
She makes some, but sometimes she just discusses the evidence without making a finding.
Mr. Adams, does your position violate the constitutional right of the parent?
No, I think you've decided this in the Rowan's case, that that issue was raised, but it decided that the best interest of the child, yes, could overcome, at least be played in concert with the so-called constitutional statutory right of the biological parent. But if you take this, we'll call it a bundle of sticks, we're used to that analogy, and you give some visitation, allegedly in violation of that right in the Rowan's case, there's no difference between giving custody and visitation, because it's the same protection if it's protected. And in any cases discussing that protection, the welfare of the child, the court has always held, should govern.
Your position is that since we've given the non-biological parent visitation rights, custody rights are the same, and we should therefore, in appropriate circumstances, give the non-biological parent custody.
I don't see any distinction between awarding visitation because it's the best interest of the child and awarding custody because it's in the best interest of the child.
Mr. Adams, let me ask you this. The focus in this case appears to be between a biological parent and a de facto parent. But think of this example. Husband and wife are married. Wife conceives child. Child is, by any stretch of our law, son of husband. They are subsequently divorced, quite soon afterwards it might be. I'm not talking about, one of these 20-year things when it turns out that was somebody else is a different father. I'll get to that example next. It is then determined quite quickly by the mother that the marital father is not the biological father.
Yes.
Right?
All right.
And now we are, 8 years? How long did she have custody? I mean, was the primary parent?
She had the better part of 8 years, about 7, a little over 7 years, as she actually had custody.
8 years later, the biological father, the marital father, comes in and says, I want, visitation, custody, whatever you want to say, with my son.
Yes.
So do we put biology over the marital father?
No. I say you go with the best interest of the child. That should be the...
So now we have marital father for 20 years, didn't know wasn't the biological. I mean, you can see how all of these
Yes.
play out.
Yes. But I submit that the test of best interest of the child...
So when we talk about constitutional principles, has the Constitution spoken about parents, legal parents, or about biological parents?
It has spoken about both, as I recall. You have a case where a father, a man, agreed to be the father of a child he thought he was, and supported that child for years. And then DNA came around and he found out he wasn't and tried to get out of it. And the court held him to it because he had been the parent father to that child for 18 years until the child reached adulthood.
Using the best interest of the child standard.
Yes. Yes. It seems to me that's the only proper test. The test that of proving clear and concise evidence that the man is unfit and therefore he shouldn't have the child, that's so elastic. Where do you go? What have you told?
Well, first of all, it may not be very helpful to the relationship between two parents two people who obviously love the child. If the test is one of unfitness of the other, and we know what I mean, that is the adversary process pushed to the nth degree.
I agree, and it shouldn't be, it seems to me that shouldn't be the issue before the court in a situation like this, putting the guardian in this case to the test of proving the biological father unfit, particularly when you are told, and this court tells in its decisions, instructions to the jury, it's somewhere between more than a fair preponderance of the evidence and short of beyond a reasonable doubt. Well, that's a big area. And the case help that you've given them, I mean, I don't mean this court because it goes way back in defining that, not that you can tell the jury this, but I guess the judge could tell himself or herself, is that clear and convincing evidence means, this is from an 1876 case, strong, positive, and free from doubt. Doesn't that sound like almost beyond a reasonable doubt? And then more recently, in 1933, the evidence must be full, clear, and decisive. That's a tough burden to prove someone unfit, although I submit in this case the record justifies it. But she does not do that.
Thank you, Mr. Adams.
Thank you.
We'll stand in recess.